Choking, checked. Slapping, checked. Hitting with object, checked. Shoving, checked. Threats of violence, checked. Mental injury of a child, checked. Detaining against will, checked. Stalking, checked. Harassment, checked. And it has others being harassment, intimidation, threat, other. I guess there'll be mistreatment, physical harm. And then it goes on to describe on or about June, but does not give a particular date. That Mr. Brown apparently contacted Ms. Sanchez through an email. Then goes on to describe that on about 6 o'clock p.m., Mr. Brown parked his car across both of my garage doors, preventing my entry to my home. He eventually moved after my request, but then drove his car onto my lawn and refused to move it. I called the police, who arrived shortly. In the interim, after I drove my vehicle in my garage, he blocked my exit with his car. Early in the week, I advised that I would not release the children to him because he had not seen them in several months or spoken with them. Both girls are afraid of him and refuse to talk with him or see him. They have been under the care of a psychologist for over 2 years and one under the care of a psychiatrist on medication in part to the stressful relationship. And the quoting goes on. It is quite unfortunate what brings the parties here today. Plaintiff cites a case, says that the court must look at domestic violence in the eyes of the victim. This is not a domestic violence case. This is a custody case. And I am not at all surprised to read what Ms. Sanchez says about the children. Seeing a psychologist or a psychiatrist. Not at all surprised when I look to see a 12-inch file, and now I'm also advised that there's another part of the file that may make it 18 inches or so thick. That as young as these children may be, 10 and 6, or 10 and 7 now, they know exactly what is going on. And hearing that, in fact, on May 26 or so, 2006, that the Department of Social Services once again investigated Mr. Brown to determine allegations of child abuse. Once again, the court has been told that was ruled out. And to hear that Mr. Brown had, in fact, emailed Ms. Sanchez earlier in the week regarding his desire to pick up the children and have the children for visitation, maybe over the 4th of July weekend or whatever it may have been. The court would note that June 30 was, in fact, the Friday leading up to the 4th of July weekend. Ms. Sanchez indicated that she was not going to allow the children to go visit with him. She's also told the court that Mr. Brown is, in fact, entitled to visitation pursuant to the court's order. This is clearly a custody matter if I've ever seen one. The court must and will always look at these matters through the eyes of the victim. The question is, who's the victim? In this particular case, the children are the victim. And what they're the victim of? They're the victims of the parents not being able to resolve their disputes to move on. That's what the children are a victim of. And it's sad to the children that they must experience this. Not once has there been one shred of evidence presented in this case, not one shred, that Mr. Brown has falsely imprisoned Ms. Sanchez or the children on or about June 30th, 2006. I have no idea what has happened in the past regarding visitation, but something needs to be resolved on an expedited basis. For these children to have a meaningful relationship with both parents. Saying that, the court will in fact find that the petitioner has failed to meet or present any evidence of any domestic violence or abuse occurring on or about June 30th, 2006, and therefore, Madam Clerk will in fact grant the defendant's respondent's motion to dismiss the case at the conclusion of the petitioner's case. The question is, what's going to happen with the visitation? Now, let me just be absolutely clear. If you all cannot resolve this matter, Ms. Sanchez, just the same as you, have contacted the Department of Social Services?
You mean in the past?
Or whenever.
Oh.
I may have to contact them.
Mm-hmm.
This is not fair what you all are doing to the children.
Mm-hmm.
This is absolutely not fair.
Mm-hmm.
It's not fair. And I can imagine what was being said while Mr. Brown is sitting in the driveway, and the only thing he wants, apparently, is to exercise his visitation pursuant to the court's order. You, Mr. Brown, Mr. Sanchez cannot do what's in the best interest of the children. That's what social service is for.
Mm-hmm.
Now, I'm certain that you do not want to have these children placed in foster care.
Your Honor, may I speak?
I'm just certain that you don't want to have them placed in foster care.
No, I don't. Absolutely.
There is some psychological, I trust that there's psychological issues or psychiatric issues which are going on. Otherwise, the children should not be seeing psychologists or psychiatrists.
Mm-hmm.
Have those documents or whatever been shared with Mr. Brown?
Your Honor, I have an email right here. I've invited Mr. Brown several times to go to the therapy sessions, and he has only come one time.
What kind of sessions?
The girls' therapy session.
I just asked whether information has been shared with them.
Yes, he knows of it.
Okay. Maybe I'm lost. How in the world would a 7-year-old and 10-year-old get to the point that they need a psychiatrist or a psychologist, but for the fact of what they are observing or experiencing?
Well, do you?
No, I'm not asking for comments because, as I indicated, I'm not at all surprised when I hear you got an 18-inch thick file.
Mm-hmm.
That means you've been in and out of court, and this is just the domestic case. Now I understand that maybe 4 or 5 or so domestic violence cases. Maybe you all are a bit different than I am. I just think the most precious things in the entire universe are children. And the way you show children that they are the most precious subject in the entire universe, you do absolutely nothing at all to harm them. Now let's assume that there was something wrong with Mr. Brown having visitation. Ms. Sanchez, the way to do it is not unilaterally cut it off.
I didn't, Your Honor. He hasn't been there in 8 months.
No. When you refused to surrender and turn the children over on June 30th, that was a unilateral act. He went to exercise his visitation.
I know.
Okay. You unilaterally said no. As a result of saying no, that created the situation. He's there. Theoretical, Mr. Police, I have an order that says I'm to have visitation. You said, you drive up to your house, not only am I not going to give you visitation to give you the children, but you're going to get the heck out of the way and let me in my house. Not only now you get in the house, in the garage, the children are experiencing those kinds of things. Let's assume that was the case. He said, Mr. Brown, okay, you want to create this drama. I'm not going to subject my children to this kind of foolishness. I'm going to now, you want the children, meet me at the police station, meet me down at the district court commissioner, and I'm going to tell them what's going on. But to sit there, I want to say argue with Mr. Brown. I want to say, because I don't believe it was just a direct, Mr. Brown, would you please move your car? I don't believe it was that kind of request. And because otherwise, you would not have told the court that you were in some sort of fear if it was just a calm request. Mr. Brown, would you move your car? Mr. Brown, would you move your car? Mr. Brown, would you move your car? He finally moves it. I don't believe it was that sort of situation, which means that the children are that's my only concern, is the children. That's why I said the children.
Calm, Your Honor, it was calm.
Okay. If it was calm, then I'm more convinced in my decision now that there was no false imprisonment, that you were not in fact threatened.
Yeah, but I just kept it calm. But
okay.
I am concerned because the girl's therapist does not think that they should go with
I don't need to hear what the therapist. If you don't have, you're missing it. Let's assume that everything you say, you keep going to tell the court about the therapist. Bring the therapist to court. And your Brown, excuse me?
I did once before, and they wouldn't let her say anything.
Then they wouldn't let the therapist
waive a privilege.
You're missing it. Then why in the world are you waiving the privileges here?
I'm not.
When you tell me what the therapist said, that's not waiving the privilege?
No. I'm talking about waiving the privilege of what was said in between her and the girls. I'm just
when you tell me what the therapist would say in terms of what the children are not in need of, that's not waiving the privilege? Yes. Because guess what? That's an opinion as to what the therapist believes.
Right.
Now, listen, if the therapist came to court and some other judge would not let the therapist testify, you should not be able to come to court.
No, on another issue.
Doesn't matter. You should not be able to come to court and say what the therapist could not her or himself say.
Okay.
But you're missing it. This is all. I have no idea what went on between you and Mr. Brown. I guess 2 years after the youngest child. 2 years. I say 2 years because of the 2001 case, and the youngest child was born in 99. But somehow, you're missing it. This is about the girls.
Absolutely.
If they're having these kinds of problems now, and the youngest one is 7, for the next 11 years, you and Ms. Brown got to have some sort of contact with each other. And if it's not resolved, taken care of now, next 11 years, this young lady is going to experience this. Which means that it can't help but get worse. Had you ever thought about they just may miss their father to the extent that you need to be contacting Mr. Brown to see how there can be increased or enhanced visitation?
I've tried that, Your Honor.
Okay. Well, let me just tell you, filing this domestic violence petition did not help. Filing, and I now understand that filing at least three, if not more, matters with the Department of Social Services, which caused an investigation. How do you think Mr. Brown felt? When each time that he said I didn't do anything, and someone comes knock on his door, and they sit down and say this is what the allegations are, and now I got to go through this, maybe a different work, and they each time rule it out. And now he's saying, why must he cooperate with you on anything? Because guess what? If I grant this petition, if I had any evidence and it met the standard that Mr. Brown had in fact committed an act of domestic violence. If he does not consent, he did not consent, and I grant the petition.
You know what, Your Honor, I believe that you have gotten the wrong impression because a lot of things have happened to me and the children.
No, excuse. It's not the wrong impression. I'm dealing with this particular incident.
I understand.
Wait. I had all the evidence as to what happened on June 30th.
And
that's June 30th.
And you're saying to me about all of these jackets. The only only case that I have filed against Mr. Brown was a divorce. Everything else, Mr. Brown has filed.
Wait, domestic violence petition.
I'm talking about the
I'm
family.
speaking domestic violence
petition. But
petition.
I'm talking about the family law petition.
No.
I'm talking about 18 inches.
Well, that's what I'm speaking of, domestic violence. Because that's what I was about to say. If I had any shred of evidence that met the standard that Mr. Brown committed an act of domestic violence or abuse, guess what? And he be mad as he want to be, but now he's tarnished for life because he has a foul and a finding against him in Baltimore, or whatever it is, that's now registered nationally that he's committed an act of domestic violence or abuse. Not only that, but something may happen in the future. And for whatever it is, the parallel record still being maintained. Each time they're going to contact the local department or whatever department of social services. And there's going to be a history of allegations that Mr. Brown has committed an act of abuse. Let's assume that right now, all the evidence that I have, and I've heard that there were 3 or 4 cases of domestic violence which have been filed, all dismissed.
Yep.
There are 3 cases, at least 3 if not more, investigations which have been caused to be had with the Department of Social Services regarding child abuse or whatever. They were all ruled out. The point I'm making is, why would Mr. Brown feel as if he should try to work or cooperate with you on anything when you've caused these investigations to be had and they've been ruled out?
Your Honor, let me tell you, Mr. Brown has never worked with me on anything, and that was how we ended up with all those jackets.
Okay.
Because first he tried to, he sued me to have our older daughter removed from her private school.
I saw that.
Then he sued for custody.
Okay.
Then he appealed to custody.
Okay.
And now he doesn't show up for visitation, and all of a sudden, for 8 months, and now all of a sudden he's like demanding to have the children. The children are distressed. And he wouldn't work with me. I said, let's
missing it. There's a court order that says he needs to have custody visitation.
But is that in the best interest of the girls when he doesn't see them for 8 months?
Well, let's assume it's not. What do you have
with the girls and meet?
What do you have to say is not?
The girls.
Okay. Let me just tell you, the court could use that find that as a basis to change custody. A denial of visitation is a basis a reason to change custody. If it's unjustified, the court could in fact